delighted to introduce Barry Pollack. Barry Pollack is Julian Assange's lawyer in America. Mr. Pollack is a criminal defense lawyer in Washington, D.C., widely respected in the legal community. He's been selected into the super lawyers every year from 2007 to 2020. Barry will detail and analyze the indictment of Julian Assange.
Thank you. As we've learned here today, it was back in 2013 that Chelsea Manning was convicted of leaking the Afghan war logs, the Iraq war logs, the State Department cables to WikiLeaks, who published those back in 2010 and 2011. As was just mentioned, in 2013, the Obama administration, after Manning was convicted, it was widely reported, decided that they would not charge Julian Assange, even though they charged and convicted the leaker, because you could not, in any principled way, charge a publisher for publishing truthful information. The Obama administration referred to what it called the New York Times problem. If we were to charge Julian Assange for publishing this information, how could we not charge the New York Times for what it does every day of the week? In December of 2017, the Trump administration's Department of Justice secretly charged Julian Assange criminally. And of course, in April of this past year, 2019, he was expelled from the embassy, and the United States sought extradition on that charge that had been pending secretly since December of 2017. He was charged with conspiracy to violate the Computer Fraud and Abuse Act. If you read the Department of Justice's press release, the press release said, WikiLeaks found her charged in computer hacking conspiracy. Well, that's how they solved the New York Times problem. We're not going to charge him for publishing, we're going to charge him for computer hacking. The only problem is, if you read the charging document, the word hacking doesn't appear anywhere in it. When Julian said, if I'm a journalist and I write a story, if I provide you the source documents, you can tell for yourself whether or not I'm telling you the truth. He was onto something. In fact, what the allegation in the indictment is that Chelsea Manning at some point asked someone who the government alleges was Assange, but someone affiliated with WikiLeaks, for help in trying to figure out if she could log onto her computer, not under her own name, but under the administrator's name, so it wouldn't be obvious that she was the one who was leaking this material. Computer hacking, at least to me, is gaining access through a computer to something that you don't otherwise have access to. Manning had access to all of this material, had leaked hundreds of thousands of documents using her own name, wanted to continue to leak documents, but didn't want to leave fingerprints on it if you believe the indictment. Also, if you believe the indictment, Assange came back and said, no luck, I'm not able to help you. And then Manning continued to leak under her own name. In other words, there's not a single document that was leaked or published as a result of this so-called hacking attempt. A month or so after Mr. Assange was expelled from the embassy, the United States brought a superseding indictment, charging not only the conspiracy to commit computer fraud and abuse, but charging 17 counts of violating the Espionage Act. At this point, the fig leaf that this was not a prosecution about the publication of truthful information had come off. 17 counts of violating the Espionage Act. He can get 5 years for the computer fraud and abuse violation. He can get 170 years, 10 years each, on the Espionage Act charges, a total of 175 years. The government makes one other effort, I think, to try to at least disguise the New York Times problem. What they've said publicly about the Espionage Act charges is, well, we're not charging him for publishing the collateral murder video. We're charging him because he's not a journalist. What he did was he published en masse the raw data, the raw files that included the names of sources that had helped the United States putting these people at risk. And of course, no responsible journalist would ever do that. Well, again, there are a couple of problems with the government's spin. First of all, Assange had all of this material, WikiLeaks had all of this material from Manning. It could have published all of it en masse at any time and scooped the whole world. It didn't. What it did is it gave this information to the New York Times, to the Guardian, and to Der Spiegel, so that these journalistic entities could go through the material and try to redact items that would cause undue harm. While it was in the possession of the Guardian, the password, these encrypted files, became known, and a number of sources got a hold of the raw material and put the raw material online. It was only after the material was online already that WikiLeaks made the decision, well, if it's already been published, we can put it on the WikiLeaks site. So factually there's a problem there, but I think there's a bigger problem than that even. The idea that the United States government should say, we don't agree with the editorial judgments that you made about what to publish, so therefore we're going to charge you with violating the Espionage Act, runs counter to the entire history of the First Amendment. We have always believed that it is up to publishers and journalists to make the decision as to what to publish, not to the government. And I think we should all be frightened by the prospect that the United States government is going to act as the editor-in-chief for every publication, not just in the United States, but for every publication around the globe. Thank you.